Music versus Nathan Ellis.
For the record, this matter is before the court on the plaintiff mother's motion for order to show cause alleging violation of parenting time order on the part of the defendant father. This hearing is being conducted via Zoom. President Attorney Alexis Spencer representing the plaintiff mother, Tori Music. Ms. Music appears to be present with Ms. Spencer. In addition, sir, you are Nathan Elson, is that correct?
Correct.
All right, good morning.
Good morning.
Number of allegations here, Mr. Ellison. Have you since you received this motion, have you downloaded the app close app?
I have not. I will download it here in a little bit.
I'm sorry?
I said I will download it here in a little bit. I don't have it right now.
Well, you're ordered to do that some time ago.
It don't matter if I download the app or not. She talks to me through the kids anyways. She don't talk to me through her phone. She don't talk to me through.
Don't do that. Neither one of you.
She does it and blames me for it. She calls me from the kids' phone all the time.
Ms. Spencer, has your client downloaded the app close?
She has. She sent him the link about 8 times now, requesting him to download it, and he has not.
All right. And once again, Mr. Ellison, the court's going to order you. Why shouldn't the court hold you in contempt for not following this court's order, Mr. Ellison?
Why do I have to download an app? She don't talk to me anyways.
Because this court ordered it. You cannot co-parent, Mr. Ellison. You cannot co-parent. This court ordered it. This court will raise your children. It says you cannot co-parent. The court has ordered you to download that app. No communication.
She don't talk to me at all anyways unless she calls from the phone.
Mr. Ellison, do not argue with the court, Mr. Ellison. The court will find you in contempt of court for your failure to comply with this court's order by failing to download and refusing this morning to comply with this court's order to download that app. All communication with the mother shall be through this app close. So the court's holding you in contempt right now, Mr. Ellison. If we go much farther, you're looking at some possible jail time.
Jail time, but she violated it.
Parties have conferred with Mr. Walker in front of the court this morning. Mr. Walker, I presume he's made a recommendation. We're having trouble with the system this morning.
Your Honor, if you're having difficulties, I can read the recommendation into the record if you want. It should be on your on base, but I can read it if you want.
Let me just see if I close out and turn it back on, that might refresh it. And we're going to add to any recommendation that court finds Mr. Ellison be in contempt of court for failure to download the app close. Okay, there it is. All right. All right, Ms. Spencer, Mr. Ellison, the court received the following recommendation for Mr. Walker. The recommendation, if adopted, will come to the court. It indicates father admits to violating the parenting time order. Father's weekday parenting time shall be spent until he complies with the court's order. He shall download. Also, obviously, this has all been discussed before I read this. The father shall download the app close and use it for all communication. Father will make sure that Rachel Marr is not present during his parenting time. Once father provides proof that the app close has been downloaded on his phone, then his weekday parenting time shall be reinstated. If Rachel Marr is around the minor children again, then the father's parenting time shall be completely suspended. That is the recommendation. Ms. Spencer, is this recommendation agreed with your client this morning?
Your Honor, it is with one exception that I believe we just forgot to clarify. But for the pickup and drop off of the minor children, it was ordered that each parent picks up at the beginning of their parenting time. There have been issues where she hasn't been being informed about where the children even are when she goes to pick them up. She's not sure if they're at his parents' house, at his house. They've been both places. And obviously with the issue of app close, she hasn't been able to communicate about that with him through that app. And then he has been having the minor children communicate. So we're requesting either that he be responsible for all pickup and drop off, or that a pickup and drop off location, meaning one of the houses, be designated, as opposed to it just being left up for guessing and wasting time.
Okay. What about meeting at the sheriff's department or the city police department?
That would be agreeable.
All right. So both parties live in Monroe. So the court will order that the parties. Hold on, Mr. Ellison. The court's going to add to this recommendation that all exchanges shall occur at the Monroe County Sheriff's Department on East 2nd Street here in the city of Monroe. That's where you're going to meet for pickups and drop-offs. All right. With that clarification, Ms. Spencer, is this recommendation agreed with your client?
Yes, it is. Thank you, Your Honor.
All right. Mr. Ellison, do you understand the recommendation this morning?
I do, but when she just said that I have the kids call her, she calls the kids' phone all the time and asks them, where are you? Where am I picking you up? So I don't have the kids call them. she calls them and asks them if they're at my parents' house or at our house.
Well,
so don't
obviously,
say here.
she has no alternative, Mr. Ellison. When you don't communicate as a parent, as the adult, she has no alternative but to ask the children, where are you? So
Say
from
that
now
again,
on, it's
sir?
not going to be an issue, Mr. Ellison. It's not going to be an issue because you're going to be at the sheriff's department. That's where all pickups and drops is going to be. No need for mom to call the kids to find out where they're at. You're going to meet them at the sheriff's department, pick up and drop offs. So, Mr. Ellison, did you acknowledge that your sister Rachel Marr was in the presence of the children?
She gave the kids permission to let her be there. She told the kids that Rachel could be there. That's exactly what she did.
No,
just
Mr.
on the
Ellison,
floor.
hold on, Mr. Ellison, you are the party to this action. You are the adult, you are the father, you are the parent. The court previously ordered that Rachel Marr not be present during parenting time. Do you acknowledge that did occur?
Yes, I understand that. I'm at work. My kids
Mr.
are at
Ellison,
my parents' house.
Mr. Ellison,
And
Mr.
how am I supposed
Ellison.
to stop my sister?
All right,
That's my
the court will
sister.
find Mr. Ellison be in contempt of court for allowing third-party Rachel Marr to be in presence of the children
can't
as well as
stop her,
failure to
sir.
download the app close. Mr. Ellison, the court's going to assess costs today. Is there anything you want to say before the court imposes a sentence?
Say what?
The court is going to assess fines and costs against you. Actually, we're going to assess attorney fees against you for your violation of this order and hold you
But it's
contempt.
okay
Is there
for
anything you
her
want to say
to do
before
it.
the court does so?
It's okay for her to do it though, but it's not okay
Ms.
for me
Spencer,
to do it.
how much your attorney fees to date for filing this motion?
I'm not gonna.
this morning?
No, that's not even right. I already pay enough child support. I shouldn't have to pay her bills.
Mr.
I pay
Ellison,
child
you're
support.
violating this court's order. The court finds you being in violation.
not
The
even
court is held
fair.
in contempt. The court's can order you to pay Ms. Spencer's attorney fees for having to bring this matter before the court. She would not have had to come back to court, but for you violating the court order.
She's violating them too, though. How come I can't get anything when she violates stuff?
Your
You're gonna
Honor,
make me-
attorney fees are 2 hours, an hour for preparing the motion, and we're a little over an
I'm
hour.
not paying those. I will not pay those. That's not fair.
Okay, Mr. Ellison, you go to jail then. Your alternative. Ms. Spencer, what are your attorney fees?
Come get me then. Take me to
15
jail.
hours, so
I don't
we
care
got-
right now. You already took my.
Can you unmute Mr. Ellison, please? We're going to mute you because you keep interrupting, Mr. Ellison. Ms. Spencer, once again, can you advise the court of your attorney fees?
Yes, if for the total for filing this motion and the hearing today, it is $500, $250 an hour for 2 hours.
All right, Mr. Ellison, you're ordered to pay, as a result of being held in contempt, you're ordered to pay attorney fees to Attorney Spencer in the amount of $500. And I will give you some time to pay that. If you fail to pay that, the court's going to impose a jail sentence, Mr. Ellison. Just tell me right now, do you want to pay the $500? Do you want to go to jail? We can unmute him. You can unmute yourself, Mr. Ellison.
I see that now. Sorry.
Okay, how much time do you need in which to pay the $500?
Probably like 7 to 8 months or longer. Probably a
No.
year because I don't have money. I'm broke. I
Mr.
pay
Ellison,
$250 in child support, and then I have to support my kids the whole week they're here. So I give her $1,000, and then my kids are here
Okay.
7 days, and I got to support them.
all
Clothes.
right, Mr. Ellison supported to pay $500 attorney fees to Attorney Spencer on or before August 30th, 2024.
I will not be able to pay it by then.
Okay,
My hours just got cut.
borrow
I
the
need more
money,
time
Mr.
than that,
Ellison.
please. I need more
Borrow
time
the
than
money.
that.
Mr. Ellison, listen to the court. This would not have been necessary, but for your violation of this court's order. Music would not have incurred this cost of $500, but for your failure to comply with this court's order. You're not downloading
I will
app
not be
codes
able
for
to pay
being
it by
defiant
then.
this
I will lose
morning
my
and
car.
allowed Rachel Marr to be present during parenting time.
I can't stop her from going to my parents' house. That's her parents' house too.
Yes.
This is
you make sure
personal
your children
between
are not,
Tori and
before
her.
you bring your children over there, you make sure that she's not there. It's very simple, Mr. Ellison.
Okay, and
So
then
we
she
include that in your
shows up while my
recommendation,
kids are
Mr.
there and I'm
Walker.
at work.
That would be appreciated. Is there anything further this morning, Mrs. Spencer?
No, thank you, Your Honor, that was all.
Okay, and if Mr. Ellison doesn't pay it by $500 that date, you can bring it back to court and you can serve a jail sentence in lieu of paying the $500 if that's what he wants to do.
Okay, thank you.
All right, that will conclude this matter. To be mailed a copy of this order, Mr. Ellison.
Thank you.
Okay, you can all zoom out.
Your Honor, that updated recommendation should be in your queue in a few minutes here.
Thank you. I hope we get no storms tonight. Josh, I know you've not been sailing in a while.
I saw that the storms are supposed to hit right when we start going out there.
Oh, boy. Well, maybe you should have your captain sail with the North Cape sailors. They always seem to have good weather on Wednesdays.
You might want to talk to your Department of Health and Human Services caseworker to find out exactly how that would affect you, but I have to legally I have to put you in what's called non-co-op, and then they receive notice of that, and at that point,
Josh.
could lose your assistance.
Page 1, Maria Wyatt versus Kevin Wyatt.
For the record, this matter is before the court on the plaintiff's motion for order to show cause, seeking enforcement of the terms of a judgment of divorce. This hearing is being conducted via Zoom. President's attorney Leah Worka, representing the plaintiff Maria Wyatt. Ms. Wyatt appears to be present. Good morning, Ms. Worka.
Good morning, Your Honor.
Is Kevin Wyatt present on audio?
Can you hear me or?
Yes. Are you
Yes.
Kevin Wyatt?
Yes, I am.
Right. Good morning, Mr. Wyatt.
Good morning.
You and Ms. Wyatt and Ms. Worka have conferred with the friend of the court, I believe Ms. LaPrade this morning. Ms. LaPrade has provided the court fine recommendation that Kevin shall pay to Maria $21,183.49 pursuant to the terms of the judgment. Upon proof of payments, Ms. Wyatt will pay to Mr. Wyatt any payments since January of 2024. I'm not sure what that means exactly, but perhaps Ms. Worker can explain. Further, it's recommended that Ms. Wyatt shall receive the title to the Jeep as well as release of lien as soon as it is paid in full. And Ms. Wyatt agrees to keep the Jeep in full from her settlement. The issue of attorney fees is reserved. That is the recommendation. Ms. Worker, is this recommendation agree with your client this morning?
For the most part, Your Honor, point of clarification on the provision, the recommendation regarding the payment since January of 2024. Admittedly, the divorce judgment did order that my client would begin making those payments as of January. She did not, in part, Mr. Wyatt was not cooperative with giving her the information she needed to make the payment to the current lien holder. However, the other provision of the judgment of divorce was that Mr. Wyatt was to pay her the lump sum of $123,500 within 90 days of entry, which would have been February 15th. He didn't do that. He gave her a partial payment on May 8th, which would have been 173 days after entry of the judgment. My client's position is that she should be responsible for those payments since the funds were paid to her in May, or the partial payment. Outside of that, the recommendation is agreeable. My client is requesting a total of $900 in attorney's fees plus her $20 filing fee for having to file the petition for show cause.
Okay, what's this in terms of upon proof of payments, Ms. Wyatt should pay Mr. Wyatt any payments since January of 2024. What's that, payments on the Jeep?
That's correct, Your Honor. Mr. Wyatt is stating that he has made those payments on the vehicle monthly since January. We don't have any verification of any payments that were made. There's another issue that my client attempted to make an $1,100 payment on that loan on June 24th, which was later canceled. In a text message, Mr. Wyatt had indicated to her that he canceled it because he didn't know where the payment came from. That $1,100 was never returned to my client's bank account, and we don't have a way of knowing whether or not it was applied to the balance of the loan. We don't know. She knows who the credit union is that holds the loan. They refuse to give her any information because she is not listed on the loan. It is in Mr. Wyatt's name alone.
Was Ms. Wyatt gone online to check whether or not her check was negotiated?
It did clear her account, but Mr. Wyatt indicated in a text message that the payment was canceled. However, it was never returned to her. So I would assume a statement with payment history would indicate whether that $1,100 was in fact applied to the vehicle loan or not. If it wasn't, then we'll have another issue to try and figure out where her $1,100 went.
If this recommendation, I'm just confused, says upon proof payments that Maria shall pay to Kevin any payments that she made since January 2024.
Upon proof of payments made by Mr. Wyatt, then from January until now, my client would reimburse him the amount of those payments made, is my understanding of the intent.
Okay,
of the
all right. I just want to make sure. And you agree with the $21,183.49? That's the remaining balance of the lump sum due per the judgment?
Yes, Your Honor, by my math, that is the amount that she is owed from that. And again, our disagreement with the recommendation would be payments since January. We would be requesting payments as of May.
I'm sorry, I'm not quite following you. The recommendations about approved payments, Ms. White's paid Mr. White any payments since January. You're saying any payments since May?
That's our request.
Okay. And the basis for that?
Is the almost 3 months, the lump sum that she received was paid nearly 3 months after it was ordered to have been paid. Also, my client did attempt on multiple occasions to get the information from Mr. Wyatt to be able to make those payments. He refused or failed to do so. So that's why we're requesting since May. It was not her fault that he failed to pay her when he was ordered to do so.
Has the Jeep been paid in full? Do we know that?
Not as far as I know, Your Honor.
Okay, who's making the payments right now?
Mr.
I
Wyatt claims that he is.
Mr. White, how many payments are left? Let's get this Jeep paid off and done with.
I don't know exactly how many payments, but it's like, the balance is like $19,000. And, she knew who the mortgage company was or the finance company all along.
But
So
it's
it
in
could
your
have been
name,
handled
Mr.
at
White,
any
so they don't
time.
release information. Maybe Ms. Rick, you need to subpoena those records.
Your Honor, I can do that. My client is happy to pay the payoff once we know what it is. But again, they will not give her that information without Mr. Wyatt's cooperation.
Well, you can subpoena those records, can you not?
I could, that would have increased my client's attorney's fees.
You can be given any records you want on the Jeep and we can resolve this. And if she gives me the back payments, I will give her, we can resolve on the payoff and I'll give her that amount back. Less the
Who's
payments
the lien
since
holder? Is it
January.
credit union?
It's a credit union, NASA Federal Credit Union.
Okay, do they have a local branch so the two of you can meet at the credit union and go into the bank and get printouts of all this information?
No, they do not. They're stationed, located in Virginia.
Okay, well, Mr. Wyatt, since the loan is in your name, they will not provide that information to Mr. Wyatt. You need to get the printouts of all that.
I can get all the printouts and anything on this Jeep, and I think we can resolve this with Leah and Maria. Simple.
Okay, so it's obviously there's too many moving parts here. The court's inclined to put this over for a couple of weeks. Get that information, Mr. Wyatt, so we can finalize this. And you need to pay that to come up with that $21,000. Where are you gonna get that money from?
I have the 21,000, but I'm saying it would be less the payments of the Jeep that I've made so far since January.
Okay, well, you need to provide the documentation of all that. Why couldn't we have done that before today?
I don't understand why we can't. I have a phone and I haven't heard any requests. I did not see a request on the finance company, let alone Maria knew who the finance company was.
Again, Your Honor, I know the court is aware that just knowing who holds the lien does not facilitate the transfer of information where my client is able to resolve the issue. They will not speak with her or give her information because she's not on the account.
That's understandable. So you understand that, Mr. Wyatt, you need to get all information. They will not speak with Ms. Wyatt unless the two of you can have coffee and get on the phone together.
Yeah, I mean, we can resolve this some.
Okay,
Easy.
how do you suggest we resolve this, Mr. Wyatt?
I will get all the payment. We'll find out where her $1,100 went, whether it was applied to the loan or not. All the information the finance company should be able to produce, or I can get it online and give those papers to Leah and then resolve the payoff. And I will give Maria the money for the rest of the payoff.
All right, how much time do you need? Can you do that in a week or two?
Yes, I can. I
Right,
can
Ms.
call it
Larko?
right after. Yes, sir.
Well, the court suggested let's just adjourn this for a couple of weeks. Mr. Wyatt seems to be willing to secure the necessary information, get the Jeep paid off, and as well as pay any amount that's owed to Maria. We can come back and address these things.
That would be agreeable to me, Your Honor.
Let's at least give that a try. So maybe we look at 31st. We could even do it on Monday. How about July 23rd in the morning? 10:15?
Your Honor, I have an appointment that morning. I could be available early afternoon.
Can't do it. Can you move that appointment? I guess we'll
I-
look at the 30th or 31st then.
I can't move that appointment. The 30th or the 31st, I'm open.
Okay. How about July 31st at 2:30?
That works for me, Your Honor.
Right, will that work for you? July 31st, it's a Wednesday at 2:30 in the
Yes,
afternoon,
sir.
Mr. Wyatt?
At 2:30
Correct.
in the afternoon?
Correct.
Yes, that works for me.
All right, the clerk's going to print out this recommendation just for the court's information, Mr. Pratt. Thank you for that. And if we can just do a revised recommendation.
Yes, sir.
That the matter is adjourned to July 21st, 2:30 p.m. so that Mr. White can secure relevant information from the Jeep lien holder. And provide that information to Ms. Rourke. You don't need to wait till the couple days before, Mr. White. Work on that this week. Get it to Ms.
Oh,
Rourke
no, it
ahead of
will be
time.
given to her as soon as possible. And the easiest thing is if I figure out the access passwords, I will give them to her and she can look at this whole thing online.
Okay, that'd be wonderful.
Yeah.
So share that information as soon as possible. And if in fact it's resolved, Ms. Worker can always contact the court and say, Judge, we don't need to come back to court.
Okay, that sounds good to me.
Right, anything further this morning, Ms. Worka?
Not at this time, Your Honor.
Mr. Wyatt and Ms. Worka, of course, is also asking for attorney fees. So maybe you can, maybe there's a sum that two of you can agree upon to make this thing go away. Obviously, this motion would not have been necessary if you had complied with the terms of the judgment. So, and with that said, we'll see you on July 21st at 2:30.
Okay.
Thank you, Your Honor.
Post-judgment matter. The matter was adjourned from July 9th, 2024, so that the defendant could produce documentation showing that the motor vehicle, a certain Jeep, had been paid off and the lien satisfied. This hearing is being conducted via Zoom. Present is Attorney Leah Worker representing the plaintiff, Maria White. Ms. White is present. Is Kevin White present on audio? It appears that he is not. Mr. Worka, did your client reach out to Mr. White, remind him of the court hearing today?
Your Honor, we've not had any contact with Mr. Wyatt. Do you know that he was aware of the hearing? I had sent him communication on July 25th and have not received any response or communication from him.
Right, texting him, calling him to let him know that the court's waiting for him?
No, Your Honor, we have not. I sent him an
Can
email.
you, Ms. Worka, can you?
Oh, I'm
I
sorry.
didn't ask, have you? I asked, can you? If you said Ms. White doesn't want to call him, I don't know if there's a restraining order in place. If she can't be contacted, can you call him and just see if you leave him a voicemail, let him know the court's waiting for him? Maybe he simply forgot.
Certainly, Your Honor.
Thank you. Ms. Brown, thank you for your help this morning. I know things got a little hectic, but thank you.
You're welcome, Your Honor.
We were short and we had things that were stacked on top of the other.
Your Honor, I called the telephone number that I have for him and left a voicemail.
Okay. All right, so the court has received a fine recommendation this morning. So, Ms. Worker, you obviously received nothing from Mr. Wyatt in terms of documentation showing that the lien on the Jeep has been satisfied?
I received some documentation from Mr. Wyatt showing that the Jeep lien has not been satisfied.
Okay, why would he send you information that's not satisfied when he represented that it was?
Well, prior to us filing the show cause, he had represented that it was paid off. It became apparent that it was not based on comments that he had made. He, I believe, admitted when we were in court last that it had not been paid off, despite him withholding the money from my client's settlement. He had sent some information regarding the payment history of the Jeep, which I responded there was a discrepancy in that information. But the documentation he sent me indicates that there is a balance owed on that vehicle.
And we don't know where the title is that correct?
We do not. I believe that Mr. Wyatt had indicated that he did not have it, or if he did have it, he didn't know that he had it. But it's not in my client's possession.
And there was no discussion about the title to that Jeep when this judgment verse was entered, is that correct?
I don't believe specifically it was awarded to Ms. Wyatt. We did reach that agreement through mediation.
Yes, the plaintiff Maria was awarded that Jeep. And defendant was to make the payments for October, November, December, and plaintiff make the payments from January 2024 forward. So she's currently making those payments. Is that correct, Ms. Werka?
No, she has not. She had not been provided with the information or the authorization to do so from Mr. Wyatt.
Great. The recommendation this afternoon is that defendant shall pay plaintiff for the remaining installment of $21,183.49, cooperate with obtaining title to the Jeep, execute the necessary documents to allow plaintiff to communicate with the credit union regarding the loan, and authorize the credit union to release the lien to plaintiff upon paying the loan in full. I think what the court should do also, Ms. Brower, if we can put in language, maybe even somewhere, the court can order that Mr. Wyatt personally appear, and if he fails to appear, the court can issue a bench warrant for his arrest. This order, he's can ignore it, and we're back to step one. Maybe Ms. Werka to get his attention, maybe rather than ordering all these particulars, maybe the court simply note that he's failed to appear today, order him to personally appear. We'll give him a specific date, and then the order can say that's fair to appear result in issuance of bench warrant. Hopefully that'll get his attention. Any objection to that? I want to get this. We need to bring some matter to some closure, and that's perhaps the best way to get Mr. Wyatt's attention.
I would agree, Your Honor. My client's frustrated. She's been trying to resolve this matter without success. I would expect, or at least hope, that would result in getting Mr. Wyatt's attention.
So, Mr. Wright, I wonder if there's a last line that's blank. Maybe you can type it in capital letters or bold language. Defendant Kevin Wyatt shall personally appear before Judge Braunlich, and we'll give you a date. And then we can put a semicolon fair to paper result issue of a bench warrant, just so that he is well aware. Do we have a time in a couple weeks? The 28th then.
No, the 21st, I can do it 2:30.
About the 21st and August 21st. I'm sorry, 2:30 and August 21st, Ms. Werka?
That should work for me, Your Honor, yes.
So the court will order, we add to this recommendation of the possible Ms. Brower, that the defendant shall personally appear on August 21st, personally appear before Judge Braunlich, August 21st, 2024, 2:30 p.m. Period fair to appear will result in issuance of bench warrant for arrest. Hopefully that language can be prominent on this order so that you can clearly see that. And right now there's a restraining order. Ms. White has no contact with Mr. White. Is that correct?
Your Honor, there's not a restraining order, but Mr. Wyatt's communication with my client has been aggressive and abusive, and so she does not have contact with him. Okay. All right. If he calls you back, Ms. Worker, perhaps suggest to him that he's got to take care of his matters, because if he fails to appear the next review date, bench warrant can issue for his arrest. I certainly will, Your Honor. Hopefully that will prod him to take action, get this done. And your client has no idea who the lender is on this automobile? She knows the name of the lender, and she's had that information, but because she's not listed anywhere on the account or on the loan, they won't communicate with her or give her any information. She had attempted to just make a payment of a random amount, and then we believe that Mr. Wyatt then canceled that payment that she made. Okay. Well, hopefully the Jeep's not going to, who's in possession of the Jeep right now? Miss Wyatt? My client is in possession of the vehicle, yes. Well, hopefully it's not getting repossessed, Miss Wyatt. We certainly hope so as well, Your Honor. I don't know why they would refuse to take a payment from a third party, Ms. Zorka. Maybe you can intervene and talk with the lender. I mean, I don't know why they would turn away money. The credit union accepted and began processing the payment. Our understanding, based on a text message from Mr. Wyatt to my client, was that he canceled the payment, alleging he didn't know who had attempted to make the payment. How can he cancel someone's check? Why can't Ms. White just mail a check to the credit union and take a check in there? Your Honor, I don't know the details. I know that the funds from that payment were my client indicates they were withdrawn from her account and not returned, but I do not see that payment applied to that loan based on the screenshots that Mr. Wyatt provided to me.
Well, perhaps you can get involved, Ms. Rook. I can't imagine a financial institution turning away a payment that someone's making. A parent making a payment on behalf of a child, I mean, they're going to take it if you have a loan number. But I'm just suggesting that to maybe get involved, because I hate to see that vehicle repossessed out of from Ms. Wyatt's driveway. Again, obviously, the longer the payments are made, she's going to be paying more interest. She's awarded the Jeep. It's going to be an additional cost to her. So maybe they can approach other ways. But in any event, hopefully, unfortunately, that's the best I can do is a month from now. So we'll order Mr. Wyatt to personally appear August 21st, 2:30. If he fails to appear, but court will issue bench warrant at that time. Anything further?
No, Your Honor, we are requesting attorney's fees.
Good. Let's see what he does.
Certainly. Thank you, Judge.
Okay, all right, that will conclude this matter. You can zoom out.
Page 1,
Thank you.
Jimmy Ringo versus Tara Ringo.
For the record, this matter is before the court on the plaintiff's motion to determine paternity. Plaintiff being Jimmy Rangel. You are Jimmy Rangel, is that correct, sir?
Yes, Your Honor.
And defendant Tara Rangel is also present. Good morning.
Good morning.
They met in front of the court. Good morning.
Good morning.
Mr. Pratt, thank you for talking with parties. If I missed something, it appears that Mr. Rangel is a little bit too late. The issue of paternity of the minor child journey was adjudicated in the 2016 divorce case.
Your Honor, I believe that to be correct. And as I told Mr. Rangel, this child is 14 and not young enough to meet the requirements, but it was also adjudicated as part of the judgment of divorce. And it appears that this motion was also filed back in 19 and at that time was dismissed.
That's right. In September 11th, 2019, the court entered an order dismissing the plaintiff's, he didn't appear on his petition. But again, the court simply denied his motion, indicating the issue of paternity of the minor child journey was adjudicated in the divorce case 2016-38533-DM. So Mr. Rangel appears the court has no alternative but to once again deny and dismiss your motion. It's too late. It's been done, already adjudicated. It should have been that your time to contest these things. And as the court calls, you agreed that journey was your child. You agreed to paternity 2016, so you can't change your mind.
Okay,
So, Mr. Pratt, if you can prepare another order just simply indicating that the motion is denied as the court determined the issue of paternity in the 2016 DM case. Any questions, Mr. Rangel?
I'd just like to know what process. I mean, obviously, I know I need to get an attorney, but I mean, she's been living with him for the last 4 or 5 years, and he would just like to have some kind of rights over her. So
I could suggest consult an attorney. I think the attorney's gonna tell you it's a little bit too late. All you can do is appeal to the Michigan Court of Appeals, but you've got to do that timely. And then it should have been addressed back in 2016 or 2019. It's simply too late.
I understand.
You can certainly talk to an attorney. And Ms. Rangel, do you have any questions?
No, sir.
And Ms. Tara Rangel, do you have any questions?
I do. Her biological father, Philip Browning, she's living with him, and I don't think it's a great environment. Do you have any suggestions as to
Talk
what
to an
I
attorney.
do?
Talk to an attorney. You're the mother of the child, correct?
Yes.
You should file and talk to an attorney, file a petition if you believe that the child could contact protective services if you believe it's a dangerous situation for your daughter.
Okay, thank you.
And Mr. Rangel, obviously you're the father of the child. Do you the two of you as parents can have that child taken from that environment? She's 14 though. She probably had a mind of her own, but she's still in the jurisdiction of this court. So you can file a petition with this court asking that the I mean, I don't know who delivered the child to that gentleman.
I did, Your Honor.
Okay, well, there you go, Mr. Rangel. Talk with Jimmy about that. He's the one that delivered the child to this third party. Who's not the legal father of the child. So this court has jurisdiction over the child. So obviously the two of you as parents can remove that child from that environment.
Okay.
All right. All right. All right, that will conclude my both Zoom out. Copy this order of dismissal will be sent to both of you.
Thank you, Your Honor.
Thank you, Your Honor.
Attorney Russell Smith representing the plaintiff, Father Alex Ortman. Mr. Ortman is present with Mr. Smith. Good morning, Mr. Smith.
Good morning, Judge. Morning.
In addition, Attorney Christina Hills is present representing defendant Mother Cameron Francis. Ms. Francis present. Good morning, Ms. Hills.
Morning, Your Honor.
Parties have conferred with Ms. Patrick this morning, who has provided the court the following recommendation. Plaintiff father's parenting time should be every other weekend, Friday at 5:30 p.m. until Monday at 7 a.m., as well as every other Thursday from 5:30 p.m. until Friday at 5:30 p.m. for the summertime. Issue of parenting time for the school year is reserved. Text messages and police reports shall be provided to plaintiff's therapist. Plaintiff will continue his therapy once a week. Parenting time exchanges will be conducted at the Bedford Police Substation by defendant and paternal grandparents. The parties shall continue to use app close to communicate regarding the children, and the parties will appear back for the court to review parenting time September 4th, 2024 to 8:30 a.m. That is the recommendation. Mr. Smith, is this recommendation agreeable with your client this morning?
Reluctantly, yes, Judge.
Thank you. Ms. Hills, is this recommendation agreeable with your client this morning?
I would also indicate reluctantly, Your Honor. I do think the recommendation, hopefully, if followed by Mr. Ortman, puts us on the right track to getting him back in a position where he can communicate and co-parent with my client without engaging in a lot of communication, which is completely inappropriate. And I would just note that if there are any more communications which do not relate directly to the welfare of the minor children, that I'll be filing a show cause and setting that for hearing as well. The communications have just been absolutely uncalled for and are very disturbing to my client. They just need to stop.
That's noted for the record, and the court's confident Mr. Smith can appropriately counsel his client in that fashion.
Judge, I've advised Mr. Ortman regarding this matter, and I'm hopeful that he can follow my advice. I'm very hopeful, Judge. So I've spoken with my client ad nauseum regarding that issue, and the communication is supposed to be regarding the welfare of the children only. Do you understand that, Mr. Ortman? Yes, sir. Okay.
Who will provide the text messages and the police reports to the plaintiff's therapist?
I will, Judge.
Okay. And you'll copy Ms. Hills with your correspondence with the therapist?
I will, Your Honor.
Thank you. All right, Counsel Joe Chavard, do your respective clients this morning?
No, Judge.
All right, the court would like to thank Ms. Patrick for assistance this morning, as well as, of course, Attorneys Hills and Smith for helping facilitate this temporary arrangement. Hopefully it will work out. Mr. Ortman, do follow the advice of Mr. Smith.
Yes, sir.
You'd be well served by doing that if you want to move forward in a positive fashion. All right, the court will adopt the recommendation, and we'll see everyone back here then on September 4th at 8:30 a.m.
Thank you, Your Honor.
Thank you. Everyone can zoom out and have a good rest of the morning. Thank you, Ms. Patrick.
Thanks, Ms. Patrick.
Record this matter is before the court for the purpose of reviewing outstanding issues. Primarily, the court recalls as plaintiff father's parenting time. This hearing is being conducted via Zoom. President Attorney Russell Smith representing the plaintiff, Alex Ortman. Good morning, Mr. Smith.
Good morning, Your Honor.
Mr. Ortman appears to be present with Mr. Smith. In addition, Attorney Christine Hills is present, as well as her client, the defendant Mother Cameron France. Good morning, Ms. Hills.
Morning, Your Honor.
Parties have conferred with Mr. Pratt in front of the court this morning, who has provided the court the following recommendation. Father's parenting time shall be every other weekend, Fridays at 5:30 p.m. until Sunday at 6 p.m. In addition, fathers shall have parenting time every other Wednesday, 5:30 p.m. until 7 a.m. Thursday morning. On the weekday does not have the weekend parenting time. Exchanges shall continue at the Bedford substation, and fathers will not be involved in the exchanges. Alex Ortman shall attend counseling every other week. The party shall continue to communicate via app close regarding the children. The party shall return to this court to review parenting time November 19th at 8:30 a.m. via Zoom. That is the recommendation. Mr. Smith, is this recommendation agreeable with your client?
Judge, I don't think it is. We've talked about it. He wants some additional parenting time because of the preschool schedule. The recommendation would eliminate a Sunday overnight. Presently, he has Sunday overnights till a Monday. And what he proposed was 3 weekends for him as a resolution. That was rejected. We would ask that the court consider that, or as an alternative, that his Wednesday parenting time overnight be every week versus every other week. Fact of the matter is, since the last hearing, Judge, there have been no incidents of any type between the parties. He's satisfied the order that the court entered at the last hearing, and everything has gone swimmingly. He's just asking for some additional time. He loves his kids. He wants to spend more time with them. And I would urge the court to consider the 3 weekends as a solution.
Ms. Hills, the
Your
court
Honor,
does note that the parenting time has been shortened from the last order of the court, taking away the 7-day overnights.
Yes, Your Honor, the court had reserved the issue of school year parenting time so that we could address that today. It's my understanding this is a recommendation for the school year. We will be back November 19th for a review. The parties also need to choose a kindergarten, so there will be lots of opportunities for them to discuss summer parenting time moving forward. And we're very hopeful that Mr. Ortman can earn back the trust that he had again lost with my client, and that they can get to a more normalized parenting schedule with more parenting time for Mr. Ortman. We are not there yet. Mr. Smith mentioned that there had been no issues, and that is true as far as the communication goes since the last review hearing. However, just in the meeting with friend of the court this morning, Mr. Ortman made some very concerning statements that still lead one to believe that he does not accept his own role in where he's at right now with his parenting time. He continues to put the blame squarely on my client in large part for his issues that he's had with co-parenting and with just completely inappropriate communication. We are very glad that that has not happened, that he's been able to do what he needs to do since the last court hearing, but I think it's clear that there's a lot more work that needs to be done on his part in therapy. So hopefully he will continue that. This schedule provides some stability for Arlo. I realize it's preschool, it's Monday, Wednesday, Friday, but the child does need some stability during the school week. We have some limitations, which were the result of Mr. Ortman's actions in terms of the logistics of the exchanges. And those are taken into consideration in the Ms. LaPratt has made as well. Mr. Ortman has acknowledged that he is not available himself during the week to be with the child, and that the children would be primarily with his parents. My client did suggest that she would be willing to do Monday evening when he has not had the weekend for 5:30 to 7:30, so that he would have some contact during that more extended period where he otherwise would not see the children. That was not accepted by him. But I do believe that this schedule that's proposed for the school year does what's best for the children. And my client has even offered again an evening in addition to that. So we are asking that the court adopt the schedule that's been recommended for the school year.
Anything further, Mr. Smith?
I'm sorry, Your Honor, I didn't hear that.
Anything else on behalf of Mr. Ortman this morning?
Yes, Judge. My client has worked very, very hard to get to this point. He's doing everything that he's supposed to. He doesn't want to move his time backwards with the children. He wants to move it forward. He's recognized the fact that his relationship with Ms. Franz is over. I think she has remarried. He's fine with that. He just wants more time with his children, and he's worked very hard to get that, Judge. So when the court read the recommendation from the friend of the court into the record, did it indicate that his counseling would be every other week going forward? I can't recall if I heard that or not, Judge.
A week, yes. He shall attend counseling every other week.
Very good. Very good. And Judge, I just ask you to give Mr. Ortman the benefit of the doubt. He's earned this. He really has. So I just ask you to award him the 3 weekends per month. Thank you.
Well, the court would note the parties did confer at length this morning with Ms. LaPratt, and the court has confidence in Ms. LaPratt being able to assist the court with these matters. And there is a review date. If in fact it's not acceptable, Mr. Smith, we'll set down bench hearing, because the court is quite honestly tired of these parties come back every other month. We should have bench hearing, be done with parenting time unless there's a change in circumstances. We bring in the counselor. We have testimony about Mr. Ortman's mental health. So either the court's inclined to adopt the recommendation with a review date, otherwise we'll just with no review date, let's set down bench hearing and be done with it. I'm really I just have this case coming back every other month for what? The last 12 months? There's gotta be some finality to this. So Mr. Smith, the court either adopts recommendation with review date or we'll set it for an evidentiary hearing.
I'm sorry, Judge, I didn't hear your last comment.
The court will set an evidentiary hearing if you're opposed to this recommendation.
You asking me if I oppose it? Was it hearing? You want to go to hearing? I don't know what that entails. 1 second, Judge, if I might mute myself. Judge, I've spoken with my client and, would you want the Monday? Part of it. Yeah, and Wednesday. Yeah. I've spoken with my client, Judge, and if previously Ms. Hills is offered the Monday 5:30 to 7:30, along with the every other Wednesday overnight, if that could be part of the package, my client is agreeable to the court entering that order.
That would be in lieu of the Wednesday overnights?
No, it would be in addition to the Wednesday overnight.
The Wednesday overnight is every other week as recommended when Mr. Ortman does not have the weekend. And then the Monday following Ms. France's weekend is what she had suggested, 5:30 to 7:30.
Correct.
Are you still agreeable with that?
Yes.
Okay.
So 1 week, it'd be Monday overnight, and the next week would be Wednesday overnights?
The Monday would just be 5:30 to 7:30, Judge. It would be
Oh, just the evening hours.
alternating, alternating Mondays, 5:30 to 7:30, and alternating Wednesday overnight.
Understood. And that's what you were referring to, Mr. Smith?
Yes, Judge.
All right, if that's agreeable, it sounds like it is, Mr. Fad, you can add that to this recommendation. And yes, hopefully the parties can, between the two of each other, discuss the childcare issues, whether they understand the oldest child is 4 years old. I don't know if it's a pre-K program or a daycare. Hopefully they can continue to discuss what's best for their children, including parenting time. And I think it's important that Mr. Ortman continue his counseling. I don't know, has he received any recent reports from the counselor, Ms. Hills?
We just got some this morning, Your Honor. I have not been able to dig deeply into them yet, but it does appear he's going and addressing his issues with the counselor.
Okay. All right, well, thank you, Ms. Hills and Mr. Smith. We'll add to the recommendation, Mr. Pratt, alternate Wednesdays, evenings.
Yes,
Now,
sir. I believe it's Monday, every other Monday after Mother's Weekend.
Right.
Correct. All right, with that, the court will adopt the amended recommendation, Mr. Smith and Ms. Hills, and we'll put this back on our docket November 19th at 8:30, and hopefully the parties can make some progress on their own.
As long as the communication is appropriate, my client is more than willing to co-parent.
That would be wonderful, Judge. That's what I've been hoping for all along, is at some point the parties will have the ability to exchange ideas regarding the children and have an actual dialogue. That would be a wonderful move forward, Your Honor.
Agreed.
Well, thank you, Mr. Smith, and the court's confident that with two very experienced family law practitioners, they can appropriately counsel their respective clients in that regard. All right, court will adopt the amended recommendation. We'll send one back on November 19th at 8:30.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
Present with Mr. Smith. In addition, Attorney Christina Hills is present representing defendant mother Cameron France, and Ms. France is present. Good morning, everyone.
Good morning, Judge.
The parties have conferred at length with Mr. Pratt this morning from the front of the court, who has provided the court with a fine recommendation that father's parenting time shall be specific as follows. With respect to holidays, parties shall follow the Monroe County Front of the Court holiday schedule. Otherwise, parenting time for father shall be as follows. Father shall have every other weekend, Fridays at 5:30 p.m. until Sunday at 6 p.m. In addition to every other Wednesday, 5:30 p.m. to 7 a.m. Father shall also have the Monday following Mother's Weekend from 5:30 p.m. until 7:30 p.m. The exchange of the children, I should say, shall occur at the Bedford substation of the Monroe County Sheriff's Office. The parties have agreed to mediate with Mr. Pratt on January 9th, 2024 at 8:30 a.m. And the issue of parenting time will be reviewed by this court February 5, 2025 at 8:30 a.m. That is a recommendation. Should the court now review parenting time on the subsequent mediation if necessary? Mr. Smith, Ms. Silzer, do you want some breathing room between the mediation and the review?
Your Honor, what we discussed is if we do reach an agreement at mediation, we could vacate that review hearing. If we do not reach an agreement at mediation, I think that extra time following mediation could be helpful in the court making some decisions on what to do. Just a bit of extra time to see how things go with Mr. Ortman, a few more counseling sessions, or a couple more post mediation, and just more opportunity for him to show good judgment or the lack thereof, as the case may be. But I think that extra time could be helpful.
All right, understood, and that makes sense, Ms. Sills, thank you. All right, Mr. Smith, does this recommendation agree with your client this morning?
Well, no, Judge, but quite frankly, I think we've made progress today. The parties were able to speak cordially to one another, and my client has some holiday parenting time coming up. Hopefully, everything will go smoothly between now and the time of mediation, and we can mediate it to conclusion on the date set and eliminate the other court date. That's our hope, Judge. So we wanted to move the meter today. We weren't able to get that done, but I think that both parties understand that it would behoove them to move the meter forward as things go along in this matter, Judge. So although we're not delighted about the recommendation, we are willing to accept it at this point with the idea that when we return, that things will move forward. So, yes.
All right, thank you, Mr. Smith. Ms. Sills, is this recommendation agree with your client this morning?
It is, Your Honor. And my apologies to Ms. LaPratt. I should have raised this issue with her, but it is our understanding and expectation that Mr. Ortman would continue his every other week counseling in the interim.
Any objection, Mr. Smith?
No, Judge. I think that would be fine. Mr. Ortman, do you have an objection to that? No. No, I think it's helpful, Your Honor.
All right, perhaps we'll get Ms. LaPratt can do her magic and add a sentence to this recommendation for the court to adopt that the plaintiff father shall continue his counseling every other week. Right, with that addition, Mr. Smith or Ms. Hills, do you wish to voir dire your respective clients?
No, Your Honor.
No, Judge.
Well, obviously, the court would note they're both involved in these discussions for the last hour. Very well. I would like to thank Mr. Pratt for her efforts this morning, as well as, of course, Attorney Smith and Hills for helping the parties reach this agreement. And the court will accordingly adopt same with the addition that the plaintiff father shall continue counseling every other week. And that will conclude this hearing. Everyone can zoom out and have a good rest of the day.
Great. Thank you, Your Honor.
Thank you, Judge. Have a good day.
Mr. Durant, can you, what's your current mailing address?
221.
For the record, Mr. Durant is appearing this morning via Zoom from the Monroe County Jail. He's been arrested on a bench warrant within the last 24 hours. Also present is Monroe County Front of the Court Attorney Rebecca Hicks. Mr. Durant, are you being held on jail on any other criminal charges, or just as front of the court bench warrant?
I turned myself in. I had a incident last summer that I didn't know was still in the courts that I have to get taken care of, as well as this. So I came and turned myself in yesterday.
And what type of matter did you turn yourself in on?
It's attempted assault.
Okay. Is it a felony?
No, I don't believe so. I haven't been sentenced on it yet or anything.
Well, have you been arraigned on it?
I believe so. It's more up in the air than I realized. That's why I came to turn myself in and deal with it.
Okay. Do you have have you been convicted of something?
I'm waiting to get my PSI done on it right now.
So you've been convicted of something and you failed to appear for sentencing. Is that the situation?
Yes.
All right. Right. It appears that the court probably requires some sort of cash bond. You know, you turned yourself in, Mr. Durant. Ms. Hicks, can you provide the court some background information regarding Mr. Durant?
Certainly, Your Honor. In this matter, it is an arrears only case. Support ended in May of 2021. However, that arrears balance is $17,064.86. We last received a payment on April 8th of 2024 in the amount of $56.44 from income withholding. There is a previous finding of contempt. It's from February 16th of 2022. It is a first finding, and we do have a 38-day balance.
I'm sorry, 38?
Yes, 38 days.
Thank you. All right, Mr. Durant, with whom are you currently employed?
I'm not. Again, that's why I'm turning myself in. Like I just came back to Monroe in 2023. I'm finally starting to get back on my feet and whatnot. I have potential employment lined up. I've got an actual family member letting me stay with them that's not crazy or alcoholic themselves. I've got about a year sober right now. I'm trying to move forward. So I came to turn myself in and yeah.
Are you aware that, sir, you have outstanding arrearages of $17,000, which will not go away?
Yes, sir. Back, I think around 2016, I'd actually tried to get signed up with the program Friend of Court here has, where you can do community service. Because
that program no longer exists, right?
I tried to get in on that back then, and they couldn't locate the baby mama for her to sign off. I don't know. They couldn't get it in jurisdiction up here, it seems like.
Right.
But I have actually been trying to deal with this.
Well, he could have appeared, though. There's been a bench warrant outstanding. He could have appeared much earlier and made some payments on it. There's an involuntary payment made in April of 2024, so you're employed back then. In any event, you have 38 days to have your head. And if you don't make some significant dent in this obligation, the Attorney General is going to charge you with a felony non-sport charge for which you go to prison. I'm letting you know, I'm surprised they've not done that yet. Generally, you get over 15,000 rears, you're on the radar for the State Attorney General to take over this case, charge you criminally. So do you have anyone that can post a bond on your behalf? Of course, you require a cash bond.
No.
All right. Who do you live with?
It's my cousin. He's actually on SSI. Like he's not getting any kind of rent from me or anything. He's just giving me an opportunity to kind of get on my feet. Like that's like he knew I had the warrant. He made me come up here and deal with it. That was part of me being able to stay there.
Well, that was probably the criminal warrant.
Well, no,
both. Do you own any property of any value?
No.
All right. Ms. Hicks, do you have any questions of Mr. Duran?
No, I have no additional questions, Your Honor.
Okay. Recommendation, Ms. Hicks?
Your Honor, my recommendation would be 7 days immediate jail credit for the 1 day he has served, or $1,000.
What do you suggest for a review date?
August 20th at 1 p.m.
Okay. Mr. Duran, anything you want to say before the court imposes a sentence?
Like I said, I'm trying to get this actually addressed. Like back when I was trying to get in that program, it was when I still maybe would have had a chance to have some kind of rights with my kid and whatnot. Like I really have tried on my end. Between me and the baby mama, she just always wanted me to sign my rights away, and I wouldn't. So actually, I'd rather pay this 17 grand than her be able to tell my kid that I signed my rights away. So yeah, like let's get the ball rolling so I can pay this.
All right, Mr. Durant, the front of the court has a 4-page list of employers that are screaming for employees. I can get your job today if you're so motivated.
Absolutely.
So when you get out of jail, you come to the front of the court, meet with your caseworker,
yes, sir.
Get a copy of the jobs list, start making payments.
Does this qualify me to go to Michigan Works, or can you guys get me the referral for that?
Come and talk with your caseworker. Yes, they can make your referral to Michigan Works, but they got a 4-page list you can contact directly. So, Mr. Durant, the sentence of the court, you got 3 days of your head. The court's going to follow my 6th recommendation. You order to serve 38 days in Monroe County Jail as follows: 7 days immediate, but give him credit for the 1 day you have served. That means 6 days in jail, but you can release this afternoon upon posting a $1,000 cash bond. Keep in mind, with a sentence, you've still got 31 days hanging over your head. You hold the key to that jail, Mr. Durant. If you cooperate and work with the front of the court, you can avoid the additional jail. We got, even after the 7 days, you've got 31 days hanging over your head. You're ordered to appear before the front of the court for review before Ms. 6, August 20th at 1 p.m.
Yes, sir.
A copy of this order will be sent over to the jail. You get copies before you release. So again, when you do get released on the criminal charge, come over to the front of the court, talk with your caseworker, get a copy of the jobs list, get back on track, hopefully get out of jail on the criminal charge and make some payments between now and August 20th. If you fail to appear on August 20th, guess what? Another bench warrant's going to issue. Do you have any questions, Mr. Durant?
No, sir.
Okay, you can step out.
All right.
Welcome. The court will cancel that bench warrant. Provide the court some information about
Thank
Ms.
you, Your Honor, and I'm
Blackburn and why
preparing that
she's
order
being
to
brought before the court
upload
this
it to you
morning.
momentarily. Certainly, Your Honor. This is an arrears only case. However, that balance is $9,540.18. We originally were here, or last here on June 4th. At that time, it was put over to today's date. Ms. Blackburn was to provide the friend of the court with medical documentation showing that she was unable to work, as well as begin paying $25 biweekly on her arrears. We were here before that on May 7th, where again, she was supposed to have provided at least medical documentation of her inability to work. So on 2 separate occasions, there have now been an order for her to provide the friend of the court some sort of medical documentation saying that she's unable to work, and she has failed to do so, and she has failed to make any payments of recent time. We did receive a lump sum payment in March of this year. Prior to that, we had received a payment from income withholding in February of this year, but we have not received any payment for the past several months, nor any documentation from Ms. Blackburn showing that she is unable to work at this time. So at this time, the friend of the court is requesting a finding of contempt.
All right, so Ms. Blackburn, do you understand you're being charged this morning with civil contempt of court for failure to pay child support and or provide medical documentation? Upon conviction, you could be ordered to serve up to 45 days in jail. Since there's a very real possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all that?
Yes, I do.
Are you asking for court appointed attorney, Ms. Blackburn?
Yes, I can't afford an attorney.
Okay, all right, so Ms. Blackburn, let me ask you a few questions. Are you are you currently employed?
No, not at the moment.
Do you receive any income?
No, I don't.
How do you support yourself?
My fiance.
Okay, your fiance better start paying the support, otherwise you're gonna spend a couple weeks in jail. Do you own any property of any value, Mrs. Blackburn?
No, nothing.
All right, the court will grant your request for court appointed attorney. Ms. Blackburn, you are to personally appear before this court on Thursday of this week. That's July 11th, 2 days from today's date, July 11th, 11:15. Bronx Court, fourth floor of the courthouse. If you fail to appear, the court will issue a bench warrant for your arrest. And the court is going to suggest to you to bring $1,000 to pay towards your arrearages or bring your toothbrush. Because there's a real distinct possibility the court would be inclined, if you can make a significant payment, the court would be inclined to adjourn this matter. If not, there's a real distinct possibility to go to jail that day. And the court would also suggest if you claim that you are medically disabled, you need to bring documentation with you on Thursday.
Right. I'd have to go down to Henry Ford. I've been on my first treatment that I started for hepatitis C, made me very sick. So they put me on Mavericks. I've been on Mavericks for 3 weeks now. I still have 6 weeks to go.
Okay, you need to bring documentation and $1,000, Miss.
Okay, so on July 5th, my car was hit outside my home by a drunk driver at 7 a.m. I'll have to find a way to get to court. Is there any way I can move that date?
No, you have your fiance bring it down here.
Well, no, like we only have one car and it's in my backyard right now. This guy totaled out my car from the rear end all the way with my front bumper off. Everything looks like my car has been opened with a can opener.
So if I gave you till Monday of next week, is that gonna make any difference?
It might. I could ask around. I'm an ex addict, a heroin addict. So I moved back to Michigan last January. I don't speak to nobody. I don't have no social networking, no nothing.
Miss Blackburn, will it make a difference for your getting down?
I will try. Yes, I will try for Monday. I will try to find my hardest to find a ride.
Okay, so yes, the answer to the question is yes to make a difference by a schedule for Monday rather than Thursday.
Yes, yeah, well, yes.
All right, so it's July 15th. Make a note. July 15th. That's Monday next week, 11:15. Personally, you appear in Judge Bronx Court. I'm suggesting bring medical documentation that you're unable to work. Bring $1,000 and or a toothbrush.
All right.
And the $1,000 we apply toward your arrearages. It's not going to go to fines or court costs or anything. It's going to benefit you 100%. So you got time to reach out to. If you need to sell that vehicle, if it's damaged, have your fiance get some money together. Do you have any questions, Ms. Blackburn?
No,
let me give me a cell phone number the attorney can call you.
Okay, 313.
So the attorney will probably contact you later this week to discuss this matter with you, and the attorney will be here with you at 11:15 on Monday, July 15th.
All right.
Anything further, Ms. Hicks?
Nothing further on this matter. Thank you, Your Honor.
Okay, Ms. Blackburn, you can zoom out, and we will see you personally on Monday, July 15th, 11:15 a.m.
All right, thank you.
Welcome.
Bye-bye.
Yeah, can you hear me?
Yes.
Okay, this is Tynan Rubin.
Okay. Ruben.
What's that?
And Ruben, present on audio.
Yeah, this is Tynan Rubin.
Mr. Rubin, can you please state your name and current mailing address for the record, please?
Tynan Rubin.
Ms. Hicks, can you provide the course information regarding Mr. Rubin and his obligation to pay child support? Mr. Rubin, obviously, you're brought before the court. You're inching your way closer to spending some time in jail. So this is serious when you're brought before the court. Ms. Hicks will provide the course of background information for the benefit of the court.
Certainly, Your Honor. This case has a current monthly support obligation of $417 per month. The current arrears balance is $5,608. We were last here in our show cause hearing on May 7th. It was adjourned over to today's date for him to pay his June and July payments. Our computer system does not reflect any payments. Mr. Rubin stated when he met with the FOC earlier that he made a $600 payment online, which is not reflected in our system. And until it clears, we do not count. Even with that $600, he would still be $234 short in just his current support. And we've been limping this along, and he has not made these payments. So at this time, the friend of the court is requesting a finding of contempt.
All right, Mr. Rubin, do you understand you're being charged this morning with civil contempt of court for failure to pay child support? Upon conviction, you could be ordered to serve up to 45 days in jail. Since there's a distinct possibility of jail, you have the right to an attorney. And if you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all that?
I do, Your Honor.
Are you requesting a court
appointed attorney? I have confirmation.
Mr. Rubin, are you requesting a court appointed attorney?
No.
Are you going to represent yourself?
Yeah, I made a $1,000 payment. I have confirmation numbers for him through the MISDU website.
When did you make those payments?
A few days ago, so that's why I have a confirmation number so you guys can use it to reflect against the case.
Right.
I was trying to speak earlier, and I was cutting in and out with the lady I was talking to earlier.
But you, of course, you still got pretty, even with $1,000 payment, you got arrearages of $4,600. It's pretty significant.
I understand that. Yeah, I've been making larger payments to take care of the arrears. My obligation is $470, and a majority of my payments have been $500. So I've been trying to scratch away at some of the arrears that I had built over the time. But
Are you currently employed?
I'm working for a family business. Yes, sir.
Okay, and are you a 1099 employee?
No.
Okay, what's the name of the family business you work for?
Sparky's.
I'm sorry, can you spell that?
SPARKYS.
What kind of business is that?
It's a donut shop.
Okay, are you working full-time, 40 hours a week?
Just about, yes, sir.
Okay. Ms. Six, how long does it take for your office to verify that payment that was made? Mr. Rubin claims he paid $1,000 a few days ago.
Until they clear, Your Honor, which can take 3 to 5 business days, he can retract it whether we see his confirmation number or not. So until it clears and shows in our system, that's why we do not count it.
Okay.
Okay.
What's your thoughts about what's your thoughts about adjourn this for a week to verify that payment, and then if necessary, if in fact he paid $1,000, would you be inclined to hold off any contempt requests?
I would, but I will now go to adjourning his to only monthly because he never pays consistently, which is what friend of the court and what your court order requires of him.
Okay. So are you asking the court to move forward with the contempt?
No, Your Honor, I would be agreeable to doing a very short adjournment to see if he actually made that $1,000 payment.
All right. So we'll adjourn this to the court's docket. When you suggest, Ms. Six, what day next week?
How about Monday at 11:15, since we already put that other case over for that date and time?
When did you make the last payment? Was it this week or end of last week?
What's that?
When did you make this $1,000 payment? Do you remember what day it was? Mr. Rubin, do you remember what day you made the payment?
He's talking that we can't. We cannot hear you.
Can you hear me?
Now we can. When did you make the payment? Do you remember what day it was?
Saturday.
Okay. So we should have a confirmation by next Monday, correct, Ms. Hicks?
Absolutely, Your Honor.
All right, Mr. Rubin, keep this phone number. You're to appear before this court at 11:15. You can appear by phone on Monday, July 15th. Next Monday, 11:15. And we're just going to verify that you made that payment. And hopefully that would cause us to adjourn this matter without commencing contempt proceedings, okay?
Okay.
And if you can, make a note, Monday, July 15th, 11:15, maybe call this number. It's much clearer than your Zoom attendance. Ms. Ruffle, you can appear if you wish. You're not required to appear, Ms. Ruffle. The court knows you were present. It's totally up to you if you wish to appear.
Okay, thank you.
Ms. Six, anything further?
Nothing further, Your Honor. I'll prepare that order and upload it to your queue.
Mr. Rubin, do you have any questions?
Yeah. So I work for a family business, and we're struggling with money as well. And I understand I have an obligation, but sometimes things do get tough, and I'm still trying to keep a roof over my head for my children when I get them. And I'm not pointing fingers at other people and saying that I don't count, but when I get a little bit behind because I'm struggling, I feel like it's how everybody's coming at me is a little stronger than it would be versus other people. There's people that are thousands of dollars behind on support, and I'm just a few grand, but that's built up over time. I've never been negligent. I've always been paying into my support and stepping up, and people hit rough times. You know what I mean? So
okay,
I just feel like I'm being mistreated a little bit.
Well, Mr. Rubin, the fact is you didn't make a payment for June or July. That's what caused this case to be brought before this court. There were no payments made in the last 2 months, so that's understandable.
Right.
But yes, hopefully
I still
retract that. Hopefully we can confirm that next week, and then we can put you back on the front of the court docket for review. So just keep in contact with the front of the court. That's huge. If you can't before the 417 a month, then file a motion to reduce your support. Just be proactive. That's all we're asking, Mr. Rubin. Be proactive.
So if I can't pay the full obligation every month, so I need to file for a review.
Yes, and file a motion to reduce your support. I mean, he's got to be proactive. Just don't sit on your hands. You don't want this arrears to pile up on you, Mr. Rubin. The front of the court is here to help you. We're not here to make things difficult on you. So the fact that you didn't pay any payments for June or July, that's what brought the front of the court's attention. Rightfully so.
Okay.
So in any event, hopefully on next Monday, the 15th of July, we can confirm that and then we can move forward. Okay?
Okay. One more thing. Going back, I believe you set the child support at like $15 based off of $15 an hour. And I had spoke with you in the courtroom in person and telling you that that's really high, and I'm not making that kind of money. And this is what you set it at. So if I filed for a review, I mean, is it even going to do me any good?
I don't know. Talk with the front of the court, your caseworker. I don't know when you were asked before the court when you reviewed support, but $15 an hour is not much these days. If you maybe need to look for another job, most people are making more than $15 an hour.
Well, I'm working for a family business, so I don't have much of an option. I can't just walk out right now, I'm still paying support and supporting my own family, but I can't just walk out of something.
Okay. I cannot answer your question. I'm not sure when this amount of support was set. Was it set
Your
a
Honor,
couple years ago?
I can. For the record, it was not before you. It was before referee McKee. the recommendation, they had a hearing with the referee McKee, and for defendant's income, he used $9.75 per hour to calculate the current support order.
And when was that, Ms. Hicks?
February of 2022.
Yeah, he set it for 15 an hour.
No, he used $9.75 per hour to calculate your support. You can get a copy of this at the county clerk's office at the second floor of the courthouse, which is also where you file your motion to modify support.
Okay, so I'll just have to file a motion again because I don't want to argue with anybody, but that's what the gentleman had told me. It was based off of 15 an hour. So
Well,
I don't
Mr.
know what
Rubin,
you put on the books.
Well, the court suggests you can always come down in front of the court. You can talk personally with your caseworker. Your caseworker can provide you with a copy of that order where the referee made findings and based this amount based upon your income of $9.75 at the time, not 15. I'm not sure you're getting that, but your friend of the court can show you all that paperwork.
Okay,
So
well,
if you file a
I'll take
motion
care
to
of it
reduce it, the motion to modify support could go up. So you got to be careful. I think I'd suggest you talk to your caseworker before you take any action. Do you know who your caseworker is?
I can't remember her name.
Well,
I'll have to figure something out.
Ms. Hicks, do you know his offhand his caseworker?
Yes, there's been a reassignment down here. I believe ours are Mark Grumman, Your Honor.
So Mark Grumman, Grummond. Mark Grumman is your caseworker.
Okay.
You call the front of the court and I have to talk with Mark Grumman, your caseworker. And they're saying, what's your last name? It's all based on your last name. So all the R's, anyone with the last name, whose last name ends in R goes to Mark Grumman.
Okay.
He can look up the file and he can say, yep, your score in 2022, 2 years ago, was based on $9.75 an hour.
So let me ask you this. So if I am paying, say I can't pay the full obligation, is that then you will issue a bench warrant because I can't pay the full obligation?
No. The front of the court always schedules hearings to talk to. What's your situation? If you're saying I'm injured, I mean, I'm laid off right now, I broke my leg, the front of the court can work with you. It's just when you're not making payments that they bring you before the court.
But as long as I'm paying something, I'm showing that I'm, still making an effort.
Well, in addition, you need to explain to them why you can't pay the full $417 a month. And that was based on $9.75 an hour.
Okay.
So keep in contact
All right.
with the court. That's the way to avoid it. But I'm glad to hear they made the $1,000 payments, and we'll hopefully we can verify that in the hearing. You can call this phone number again, 11:15 on Monday, July 15th, and hopefully that will take care of it. All right?
Yeah, I had to borrow some money to make the payment, but it's in there.
Okay. All right. We'll see you on Monday then, Ms. Rubin.
All right, take care.
You're welcome.
Thank you, Your Honor. I'll prepare both of these orders and upload them to your queue.
Thank you. Thank you. For the record, Mr. Early has been brought before this court by Monroe County Front of the Court Attorney Rebecca Hicks, who's also present for this Zoom hearing. Mr. Early, obviously, you're moving closer to some jail time when you're brought before the court. Ms. Hicks, can you provide the court some information regarding Mr. Early in this case, please?
Certainly, Your Honor. This is an arrears only case. However, Mr. Early is currently on felony non-support probation in order to pay that off at the rate of $596 per month, as his current arrears balance is $20,672.53. He was last before the friend of the court for show cause in June. He made a $350 payment that day. So we had put it over so that he could pay the remaining balance plus another payment. So we were expecting to have received $842 from him prior to today's date, and he had not made any additional payments. He has a previous finding of contempt from our court. It is March 15th of 2016. That was a first finding, and he has fully served those 45 days.
So you're asking this court for a determination of second finding of contempt, is that correct?
That is correct, Your Honor.
All right. Mr. Early, you're being charged with civil contempt of court for failure to pay child support, second offense, which is punishable up to 90 days in jail. Upon conviction, since there is possibility of a jail, distinct possibility, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all of that?
Yes, sir.
Are you requesting a court-appointed attorney?
Yeah. I was talking to the other lady like that. I was in between jobs. Like I have a consistent job. My boss is here now. I can have the 800 in by Friday. Not this Friday, but next Friday. I can pay 200 this Friday because I just started with this company this Monday, and I only got a couple-day paycheck that I get on Friday, and then I can pay the remaining next Friday. It's just I've been struggling to find consistent work, sir. With the one charge on my record, it's really hard to find a job.
Mr. Early, come down to the front of the court. The front of the court has a 4-page list of employers in Southeastern Michigan that are screening for employees.
I use
if you have a felony, even if you have a felony conviction, they don't even require drug screens. So you come down in front of the court, get that 4-page list of employers and some well-paying jobs.
No, I did, sir, and I went to Target Steel and that Jordo, and because of that, they had me go take their test, their drug test, and everything. And then when they did the background check, they denied me.
Right, but there's a number of employers on this list that are not requiring drug screens, and they do not care about a felony conviction.
Okay, I will pick it up. Like I said, I can have that 200 in Friday, and then I can pay off the remaining by next Friday at the latest. It's just, man, I've been trying so hard, sir. Like it's crazy because like with what I paid now is more effort than I've ever put in, and it sucks because I'm trying and I'm just like just hitting doors, man.
So you're suggesting pay what, $200 cash on Friday, and how much the following week?
The other 600 I could pay. That way, the whole 800 and stuff would be paid, and then I can start making payments the following week for this month.
You're saying 2 consecutive Fridays, 200 this Friday and $600 the following Friday, which is the 19th of July.
Yes, sir.
And Ms. Six, any objection if we adjourn this matter to the 16th of the 19th of July?
I wouldn't be opposed to that, Your Honor. My concern would just be that then that is just May and June that he is behind. Then we would be halfway through July, and he would, in less than 2 weeks, he would owe $596 for the month of July.
The following week, the following Friday, I can at least put $300 to $400 on it, and then by the end of the month, I should be caught up. It's just I've been out of work for a month.
Then, Your Honor, I would not be opposed to putting this over if we could put it for 11:15 a.m. on the 19th.
Right. All right. So here's what the court's going to appoint an attorney to represent you, Mr. Early. The court's going to proceed with a second finding of contempt, which means you'll have a jail hand over head, but you can avoid any immediate jail by paying the $200 on Friday and $600 the following Friday.
Yes,
so
sir.
I'm going to appoint an attorney who would have set this for hearing. You must personally appear on July 19th. It's a Friday. It's a week from Friday.
Okay.
15 a.m. Braunlich Court, 4th floor. Make sure you the first question the court's going to have is, have you paid $800?
Yes, sir.
And if so, the court will be inclined to make finding of contempt, but reserve any immediate sentence. So again, that's week Friday, July 19th, 2024, 11:15 a.m. Mr. Early, provide me with a cell number that the attorney can reach you at.
313.
Are you currently employed?
Yes, sir.
With whom?
For a company called Colossal Exteriors. I get paid under the table.
Colossal interiors or exteriors?
Exteriors.
Like a little black box.
You get paid every week?
Yes, sir.
Approximate take home?
It varies. If we have rain days, it's not so much, but at least anywhere from $8,000 to $1,000 a week.
How long have you worked for Colossal Exteriors?
I just started this week. I've worked for him before. It's just that I'm trying to look for a job. He's a buddy of mine, and he let me come back in.
That's right. Do you own any property of any value? Automobile, boats, motorcycles?
No, sir.
All right. Court will grant your request for court-appointed attorney. Again, Mr. Early, you're to personally appear on Friday, July 19th. That's a week from Friday at 11:15 a.m. outside Bronx courtroom. Your court-appointed attorney will reach you by phone in the interim and discuss this with you. Again, if you, in fact, you paid the $800, the court's inclined to impose a suspended jail sentence.
Okay.
Basically, give you the key to that jail, and if you
if I don't make the payments, then that's where I'm going.
That's correct. Correct. Do you have any questions, sir?
No, sir.
Miss Mills, do you have any questions for the court?
No, sir.
Okay, you can appear on that date if you wish, but you're not required to. That's Friday, July 19th, around 15 a.m. It will be a Zoom, even though Mr. Hurley will be here personally.
Okay.
Anything further, Miss Six?
Nothing further, Your Honor. I'll prepare that order and get it uploaded to your queue.
Okay, all right. We can zoom out, Mr. Hurley.
All right, thank you.
Welcome.
Thank you.